Hi, my name is Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney. This video is called the Simoni Principle and is designed to assist legal practitioners in the local court of New South Wales. Now, the Simoni Principle is often quoted by lawyers as the basis for wanting to amend police fact sheets, and it is probably the most misquoted principle in New South Wales, and it's one of my pet peeves. So the Simoni Principle provides that a court cannot take into account as an aggravating factor a circumstance that would warrant conviction for a more serious offence. So if a prosecutor accepts a plea to a lesser offence in full satisfaction, then they must amend their fact sheet to make out the less serious charge and not the more serious one which is withdrawn. So, for example, the law distinguishes between types of assault based on the injuries to the victim. So if you put your hands on someone and you don't leave an injury, then that's common assault. But if you leave a mark, be it a bruise or a cut, then that's assault occasioning actual bodily harm. And it might be that you're charged with the more serious offence, but the police will accept a plea to the less serious one. So if the police accept a plea of guilty to the common assault charge, then they have to amend the fact sheet to make sure that there's no mention of any injuries to the victim. A second example of the Simoni Principle being applied would be, let's say you were charged with mid-range drink drive, but you disputed that and said no, you wanted to plead guilty to low-range drink drive. Well, if the police accepted that plea to the low range, then the fact sheet could say that you had a blood alcohol reading up to 0.079, but it couldn't say that your blood alcohol reading was 0.08 because that would push you into the middle range, and that would be a more serious offence and not an aggravating factor. So that all seems quite straightforward. So why does it annoy me when so much? And it's because so many lawyers don't understand that principle, and they assert that principle in cases where it's simply not relevant, not appropriate. So, for example, there are many allegations in fact sheets which are not relevant to a charge on the indictment. So let's say that you were charged with negligent driving, and at the same time the fact sheet said that you were not displaying your P plates. Well, if you haven't been charged with not displaying your P plates, then that's not a Simoni issue, and nor is it an aggravating factor. It's a separate offence. You haven't been charged with it. It should be removed from the fact sheet, but it's not a Simoni issue. It's simply not relevant to any charge on the indictment. The second instance where lawyers will assert a Simoni issue where one doesn't exist are facts which are in dispute. So if your client is saying, look, I don't admit to this. I admit that, for example, I pushed the person over, but I didn't kick them. Well, if the fact sheet says that you kicked them, that's not a Simoni issue at all. That's just an allegation which you are disputing. It is an aggravating factor, but it doesn't amount to a more serious offence. If you're disputing it, go ahead and dispute it. Have a disputed facts hearing, but it's not a Simoni issue. The third circumstance when I often hear lawyers asserting that there's a Simoni issue is for opinion. Often there are opinions in fact sheets which are really submissions that can be put in submissions by the prosecutor, but they don't belong in the fact sheet. Now, they should be removed from the fact sheet, but it's not a Simoni issue. It's simply a case of you saying to the prosecutor, look, if you want to make this submission, that's fine, but it's an opinion and it shouldn't be in the fact sheet. My client doesn't agree with it, and he shouldn't be asked to agree with it. So anyway, just remember, Simoni means that the fact sheet is alleging facts that would amount to a more serious offence as opposed to an aggravating factor for the offence that is charged.